So this video is going to be about types of deeds. So if you find this video helpful, take a minute to like it. Comment below on the video or anything else you'd like to hear about, as well as subscribe to our YouTube channel. So let's get into deeds just for a moment. So the main deed that is out in the marketplace is a general warranty deed that says, I am conveying the ownership of this property to you in what we call fee simple title, meaning you're getting full title of this property going back to the creation of the earth. You may see a general warranty deed. It might just be called warranty deed. Sometimes you'll see things called a cash warranty deed or a cash deed. All that means is that there was no mortgage involved in the transaction. If you see the words vendor's lien associated with the deed, so a warranty deed with vendor's lien, you're going to see in the body of that deed the language of a mortgage that is being placed on the property, and that vendor's lien is being assigned over to the lender for their added protection. Now, the second type of deed that is commonly used is called a special warranty deed. And a special warranty deed is very akin to the general warranty deed, but it basically is saying that you are warranting the title of the property from the time you bought it. So instead of going back to the creation of the earth, it's just that, hey, I bought the property last week, and since then I've had good title to the property. Simple. And the deeds read very, very similar, except for a very small, less than a sentence in the conveyance clause. A special warranty deed can also have a vendor's lien associated with it. Now, another type of deed you might see is a quitclaim deed. Now, guys, it's important to know what state you're in and does your state accept quitclaim deeds. Texas does not particularly like quitclaim deeds. In January of 2022, they did pass a new rule regarding a quitclaim deed executed after that date, and that after 4 years have run, which is really the statute of limitations regarding the execution of that document, it would become a conveyance document. But you're going to find that title companies and closing agents would prefer you to get a special warranty deed rather than that quitclaim deed if possible. A quitclaim deed will come into play sometimes in a divorce scenario, sometimes in a probate scenario as well. So understand how these operate, etc., because if you can get a seller to sign a quitclaim deed, the odds are they can sign a special warranty deed. Now, one step above the quitclaim deed is a deed without warranty. It simply is saying we're conveying the ownership to you. I have some form of ownership in the property, but I'm not warranting the title to the property. Now that can be sufficient, but again, some lenders and title companies don't like deeds without warranty. So like a quitclaim deed that says I am quitclaiming whatever interest I have in the property to you, it's not stating that you have a known interest. Whereas with a deed without warranty says I do have some interest in the property, I'm simply not going to warrant title. Maybe you bought a property at a foreclosure auction, for instance. You got a trustee's deed, and now you're going to convey that to a back-end buyer somewhere, and you don't want to provide them a special warranty deed. You'd prefer to give them a deed without warranty. Oftentimes, in a situation like that, that deed without warranty is going to suffice in most instances. So then we have some deeds that we utilize in default scenarios. One is called a deed in lieu of foreclosure. And that is where a borrower can deed the house back to the lender in the event that they're in default. It prevents the foreclosure. And guys, I've yet to find anybody who wants to be foreclosed on if they don't have to. And so often, especially in the creative finance world, when you communicate with your borrower, you are able to negotiate a deed in lieu of foreclosure in the event of a default and not have to go through the foreclosure process. Now, if you're going to utilize a deed in lieu of foreclosure, always, always, always check the title before you accept that deed to ensure there aren't any liens that have been recorded against the borrower. Because when they deed that house back to you, your lien will go away, and those liens that were against the borrower may jump in and take priority and be in first, second, or third lien position that you don't want. So be cautious of the deed in lieu and know how it works. So oftentimes in lieu of a deed in lieu of foreclosure, I see what is called a performance deed. And that is where a buyer gives a seller, usually it's an investor, giving the seller a deed that says, hey, in the event I default, you can take this deed and just record it and you get the house back. Now when you're doing that, what you're really doing is you're circumventing the foreclosure laws of your state. So make certain you understand if you can utilize those deeds or not. Here in the Texas marketplace, there are some statutes that directly involve performance deeds, and basically they can be set aside. And so I don't necessarily like the utilization of a performance deed, but if your state allows them, it's not a bad tool that might convince a seller to go ahead and sell you the property. Then there's the trustee's deed and a sheriff's deed. And these are deeds that come out of a foreclosure of some format. So a trustee's deed, sometimes it might be a substitute trustee's deed if the original trustee has been substituted, is a document that the trustee provides to the buyer at a foreclosure auction. And what that is doing is conveying the ownership of the property to the highest bidder at the auction. Now, a sheriff's deed is very much like a trustee's deed, except these are come out of tax sales, whether it's an IRS or a property tax foreclosure, and or a judgment lien foreclosure. And in those instances, the sheriffs typically conduct those sales instead of an independent trustee. Therefore, it's called a sheriff's deed, which conveys the ownership of the property to the buyer. So make sure you understand all the deeds that are out there, what their various effects are. So when you are buying property, you're obtaining the type of deed that you really want and getting the maximum title that's going to be available to you. So if you like this video and find it useful, take a minute and like it. If you have any comments or questions, take a minute and check below, and we'll try to answer those for you. And be certain to subscribe to our YouTube channel. So if you want to learn more about owner financing and how to do it the right way, take a minute and check us out over at the ownerfinancenetwork.com, where you're going to find all of our paid courses and all the services that are available to you for your next owner finance transaction. We'll see you guys next time.